Good morning, Mr. Chair and Senator.
No, actually, we have two senators, the vice chairman.
Mr. Chair and
Oh,
Senator.
Got it.
I'm trying to get my grammar correct.
Oh, no, you're fine.
I'd like to start off by saying I accept the committee amendments. I appreciate your staff working with my staff to even make this bill better. Assembly Bill 67 is a pretty simple idea. It simply says that if people have to work on Thanksgiving, that they should be paid double time. It codifies an industry standard that has been set by Unionized Grocery Store for decades. And unfortunately, in the last few years, we've seen more and more large retailers decide that they need to open up on Thanksgiving. The problem for so many working families is they're not given a choice whether or not they can work. They're told they have to. And there is nothing in California state law that requires any additional pay for that time that was traditionally spent with family for them to be away from their families. It's created some outrage, but not enough to prevent these large retailers from opening up and deciding it's a good shopping day. So this would apply only to large retailers or grocery outlets with over 500 employees in the state, and the restaurants, all, of course, chain restaurants that operate within those retailers. Everybody else is exempt. We keep adding more and more to make sure people feel good that they really are exempt from this bill. This is targeted at a group of employers that absolutely can afford to pay a little bit more on this family holiday and can make a decision that if their profits are so high that they must remain open on Thanksgiving, they can at least share in those profits with their employees. So that's the basic notion of this bill. I have some folks to testify in support, and I respectfully ask for an aye vote.
Great, thank you. Witnesses in support.
Thank you, Chair and Senators. My name is Julie Fisher, and I'm here in strong support of AB 67, the Double Time Pay on the Holiday Act of 2016. For the past 31 years, I've been a retail worker at Macy's. As more and more retailers open on Thanksgiving Day, working the holiday takes many of us away from our families and our celebrations. I've seen many of my colleagues working without fair compensation on this holiday. Fortunately, I'm a union member of UFCW Local 5, and they have provided fair compensation for the workers on Thanksgiving Day. For all the workers that are required to work, this should be a standard across the retail and grocery industry. Another element is public transportation, which is extremely limited at midnight on a holiday, at 4 a.m. on a holiday. I myself and many of my coworkers have had to rely on taxi cabs just to get to work. As you know, this is an additional cost for people who are barely making enough money. Being required to work on Thanksgiving Day, and as a result, missing celebration on this traditional holiday with our families, deserves double time pay as fair compensation. Members, I kindly request an aye vote. Thank you.
Thank you. Other witnesses in support.
Good morning, Mr. Chair. Good morning, Senator Stone, senior staff. Symbolically speaking, last night the glass ceiling was shattered in American politics and American history. We are confident that AB 67, authored by Assemblywoman Lorna Gonzalez, will follow that same path. Given that in the food retail industry, over 50% of the workforce are women and a majority are Latino. So now let me share to the opponent's argument that the costs are too high. In 2015 alone, according to their own reports, and during the 7 days holidays beginning in Thanksgiving, they generated over $93.9 billion of sales in 2015. We have in California over 20 million consumers during that span of holiday shopping. In our industry, in the food retail industry, in 2013, the food retail industry in California generated in gross revenues $98.2 billion. Data that we have from 2011, the California food retail industry paid workers approximately in wages $7.7 billion. Obviously, for the common person, you can see there is a gap. From 1990 to 2012, general merchandise employment grew 176%, from 41,000 employees to 100 employees across the state. This is a growing, vibrant industry. There are approximately now almost 400,000 food retail workers in the state of California. However, 36% of the California food retail workers use some form of public assistance, costing the state over $662 million. And I'll last with this point. According to EDD data, in the next 10 years, they project that the retail industry will need over 250,000 workers to meet their needs of expansion in the state of California. Mr. Chair, Senator Stone, members of the committee, we respectfully ask for your aye vote.
Thank you so much. Others in support, please step forward and identify yourself, please.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also in support.
Thank you, Mr. Chair. Members of the committee, Jeremy Smith here on behalf of the State Building and Construction Trades Council, also in support.
Good morning, Mr. Chair. Kira Ross on behalf of the City of Glendale in support. Gina De Silva with the California Immigrant Policy Center in support.
Thank you, Mr. Chair, and Senator Tristan Brown with the California School Employees Association here in support. Thank you.
Mr. Chair and members, Mike Belote on behalf of the California New Car Dealers Association wanted to indicate that as amended on May 19th, we've removed our opposition to the bill. Want to thank Ms. Gonzalez for working with us. Some of the unique ownership attributes of new car dealerships we think made the exemption appropriate, and we thank her.
Okay, thank you.
Mr. Chair and members, Mike Dillon representing the California Ski Industry Association. They were neutral on the bill. We just want to thank the author and the committee and the staff for amendments exempting the ski industry. That's a day when families like to go skiing and enjoy the day, so we appreciate the amendment. Thank you.
Thank you. All right, any others in support? Seeing none, can we have the opposition step forward, please? We'll make some room here for them to testify.
You guys can sit.
Go ahead and begin. Thank you.
Good morning, Chairman and Senator. Kate Bell on behalf of the California Retailers Association here unfortunately in opposition. The retailers are already grappling with a pretty hefty minimum wage increase and requiring that we pay double pay on Thanksgiving, which not only incorporates the double hourly rate, but also any kind of incentives and bonuses will also further add to our costs. I think one of the biggest issues is that online sales during Thanksgiving have already grown. I think they were at their record high last year. And so this is going to be pitting, the brick and mortar stores here in California who are employing Californians against the online retail sales. So that's very problematic for us. We also have problems that we're pitting large against small employers. For that reason, we're unfortunately opposed.
Good morning, Mr. Chair, members of the committee. My name is Javier Gonzalez here on behalf of the California Restaurant Association, and we are opposed to the bill. We appreciate the author's latest amendments dated May 19th, which exempt a share of the restaurant community. However, the amendments leave many in the restaurant community subject to the double pay requirement based on the mere fact that they operate within a retail or grocery store establishment. In many instances, restaurants located inside these establishments are separate and independent stores from the stores that they are located in. Most recently, the legislature enacted the highest minimum wage in the state's history, which increases it to $15 an hour and ties future increases to the CPI. Under a $15 minimum wage, once fully implemented, this bill would mean that some employees would be making $30 an hour in some restaurants. AB 67 will force restaurant operators to consider a simple mathematical question. And when it hits this tipping point, where it's no longer financially feasible to keep the doors open, businesses may simply choose to close their doors on Thanksgiving, negatively affecting available work shifts. This will negatively affect employees as it will result in the loss of their take-home pay for that pay period. For those reasons, we remain opposed to AB 67. Thank you very much.
Thank you. Any others in opposition? Please step forward. Okay. One more.
Good morning, Mr. Chair and member. Nicole Rice, California Manufacturers and Technology Association. I just wanted to get up here and say that while we were opposed to the bill in its original form as introduced, we have been talking with the author and your staff related to just a clarifying amendment that we would like to see in the definition of employer to ensure that manufacturers are not included in this bill. So based on the amendments that were taken this morning by the author, we wait to see that language in print. And at that time, I hope that we might be able to remove our opposition to the bill. Thank you.
Any other than opposition or in between? Okay. We'll go ahead and go with Vice Chairman Stone.
Thank you, Mr. Chairman. I wonder if the previous opposition could come back up again. I want to ask you just a couple of quick questions. I appreciate your testimony today, and when we had the discussions about the minimum wage, it was always a concern, and it was always a goal that we wanted to increase wages for California employees. But when you get that intersection between technology getting better and the minimum wage going higher, many businesses are considering going to kiosks and ways to do the business cheaper, unfortunately. And this is going to dramatically increase the cost of business on this holiday. And, you know, we always have business come up and tell us the horror stories about what may happen when X gets implemented, and many times we don't see it. You represent a lot of grocery stores and a lot of retailers. And, sir, you alluded to the fact that many of them are going to be making a business decision whether or not to stay open or not. I'd like to know from the grocery store perspective, it seems to be that this is where this bill is kind of directed towards. Many grocery stores are open on these holidays to allow shopping opportunities, and I think part of it is convenience, part of it, of course, is profits. But my concern is that we have employees that hope to work on this holiday. I assume they get time and a half when they work these holidays. I'm not sure what the laws are.
There's no law.
There is no law.
There is
okay.
no law.
There is no law. Many retailers already pay double time or time and a half, but again, mandating that all large retailers do it would be problematic.
And if I can, the standard which was set by unionized grocery stores, which is still a majority of the grocery stores and not where this bill was originally directed, still pay double and in my region triple time on this holiday and are making far more. Of course, those workers are making more than our 7-year out increase in the minimum wage.
Right.
So this is nothing new in that industry for this holiday.
Okay. So the $10 million question is, realistically, how many of these grocery stores are going to close if this bill were to get passed?
Goodness, I really
on that day?
I unfortunately don't have an answer for you, but
Okay.
I think it'll be problematic for a lot of them.
Okay. Sir, do you want to elaborate?
Well, I can't comment for the grocery store industry. I don't represent them. I represent the restaurant industry. So I'm not in a position to comment on that question.
Okay.
Can we ask the grocery industry?
There,
You represent-
Senator Stone, there is no data. Actually, data is the reverse. There is growth in the industry, and actually the grocery store are changing their model and following more of a Target and small Walmart model, which is basically general merchandise selling food. Okay, so it's a low cost, low price model to entice consumers in, and that's growing at a rate of 16% in the state of California.
Gotcha. Thank you, Jim. Lady, thank you very much.
All right, Sam, I have a question for you. So right now, the retail store, I mean, the grocery stores do pay the double time for the employees who work on holidays, on the particular holiday?
Depends on the, and I'm sorry. So it depends on the contract, obviously, but in unionized grocery store, I don't know of a single one in California that doesn't have double time on this holiday. And in fact, in my region in Southern California, it's triple time on Thanksgiving. And that was out of tradition. You know, they know people like to spend time with their family. Believe it or not, people want one day a year. And this bill came about from me talking to workers on Thanksgiving. Those who traditionally would be understaffed basically at a grocery store, only the employees that they absolutely needed would be compensated fully for having to miss that day. And so it's a standard that was created by unionized grocery stores. Unfortunately, we saw that explode to non-unionized grocery stores being open, as well as major retailers. And we're not talking about moms and pops. You have to have over 500 employees. So we're talking about the Walmarts, the Kmarts. Last 2 years, Kmart has decided to open up at 6 a.m. I had constituents tell me, a grandmother who said, I've never missed Thanksgiving, but I will lose my job if I don't show up at 6 a.m. at Kmart, and I will not be able to spend Thanksgiving with my kids and my grandkids. There are a lot of workers out there, I'd say a vast majority, that actually want that day off. If it's profitable enough for a major corporation to open up on this one day, then they should at least share those profits with those workers on that day.
Sounded like a wonderful close, actually.
Thank you.
Just one more
You have
question.
one more question? Okay.
Actually, two more questions. Number one, can you just elaborate on the carve-outs so I know exactly who the carve-outs are? Number two, does this apply to online retailers such as Amazon.com as well?
The carve-outs were basically, although we thought we were very clear because it was retailers or grocery stores with over 500 employees in the state, so we thought that was very clear, but everybody started getting nervous that somehow they'd be wrapped in. So the carve-outs are really just clarifying that we're not talking about amusement parks, we're not talking about a little store in a hotel, we're not talking about, even if there were a lot of them, we're not talking about the ski industry. There are a lot of traditional family activities that have gone on. What we're talking about is kind of the explosion of retailers who have decided to open up on Thanksgiving, forced workers who traditionally did not work on Thanksgiving to show up in areas where even the lowest paid workers, of course, rely on public transportation, where workers have told us stories about having to pay to go to work on Thanksgiving, miss their family, and actually just to not lose their job, not even making any money. So we tried to just keep making everybody feel better by adding any exclusion that was requested, so that we could get to what it basically is 10 to 12 major retailers in the state who have decided to open up on Thanksgiving, and of course the grocery industry that doesn't have this as their standard, who have decided, the large grocers who have decided to open up.
And of course, a lot of online retailers have Black Friday programs going on. People are ordering on Thanksgiving, so I imagine Amazon is employing people on Thanksgiving. Does this apply to them, or are they carved out?
It's not a carve out. It just, they don't fit because they're an online retailer. They don't fit into the description of a brick and mortar store. So we don't know how many people are actually working or if they're fulfilling the order the next day. That's obviously another issue, one by which can't quite be dealt with in this bill. I had another bill to do it because a lot of these are independent contractors who aren't even employees of Amazon, as we know, a large number. It does unfortunately not include warehouse workers, which I think would be the lowest wage workers who could be still affected. And I'd be happy to do another bill to do that, but this is very specific to those stores that have decided to open up and
I'm concerned about
workers.
the concerns, if you will, of retailers that are competing with these online companies. And I can tell you that we have a fulfillment center in Paris, California, in Riverside County. Another one just opened in Jurupa Valley. They employ over 1,000 people. I'll guarantee you they're working on Thanksgiving. I have no idea if they get time and a half, double time. But it seems as though you're creating a little bit of an unequal playing field. I even know people that get their groceries online now and have it delivered to their homes. So I think we're putting some of our retailers at a disadvantage that have invested in bricks and mortar, and these online companies are going to get yet another edge to get some of that business. So I see that inequity, something maybe you'll consider as you move along.
I will, and I'll point out as well, a lot of the online ordering actually comes from a brick and mortar store. So although the delivery is done by Amazon or by a contractor, the groceries, for example, often come from the grocery store, which would have to pay their workers for fulfilling those orders.
Yeah. Thank you very much.
Thank you.
Good luck.
Well, thank you so much for bringing the bill forward, and at the appropriate time, we'll bring it up for a vote.
Thank you.
Thank you. I have a next author here, Assembly Member Chu.
Good morning, Mr. Chairman and Senators. Appreciate your consideration of AB 2532, which would repeal two sections of state employment law that run afoul of federal law. In 1993, during an anti-immigrant moment in our state's history that led up to the passage of Proposition 187, this legislature passed a law that required employment service providers to verify a person's immigration status before providing services, as well as to post notices that such services were only available to U.S. citizens. Federal law, which is the Immigration Reform and Control Act of 1986, clearly preempts the state law that addresses the employment of immigrants, including the sections of California law that we're hoping to repeal. In 2012, a few years ago, in Arizona versus U.S., the United States Supreme Court again held that IRCA provided a comprehensive framework to address the employment of immigrants. The repeal of this section will not impact the requirement to verify an individual's legal status. Federal law still requires that an individual must indicate eligibility to work in our country before being provided an employment-related service. Federal law also requires that employment service providers check work authorization, and thus this posting requirement is redundant and serves no purpose other than to intimidate immigrant workers. Since federal law is clear on this authority, the presence of the state laws has caused confusion among businesses. It's unnecessary, and with that, I respectfully ask for your aye vote.
Thank you.
Jeanette Sunny Batin, Legislative Attorney on behalf of MALDEF, the Mexican American Legal Defense and Educational Fund. I'm here to testify as a sponsor and in support of AB 2532. As the Assembly member mentioned, this bill merely is a repeal bill, which would eliminate completely unnecessary and superfluous language in the Unemployment Insurance Code referring to the regulation of employment service providers as mentioned by the Assembly member. IRCA clearly delineates that this is a part of federal law that is preempted. And so any state regulation within this area, within the area of employment of individuals or employment of undocumented individuals, is specifically within the purview of Congress and therefore under the purview of federal law. And additionally, the requirement to post the notices that the Russell bill did in 1993, which requires them to post notices that those folks who are not legally authorized to work, are not eligible for these services, completely go beyond what IRCA did, and so that is also preempted by federal law. And for these reasons, we ask for your support this morning. Thank you.
Thank you.
Good morning. Gina De Silva with the California Immigrant Policy Center. We're proud to support AB 2532. As the Assembly member, my colleague, mentioned, it really is a reminder of a dark part of California's history. We really were sort of the original Arizona of the immigration debate. Immigrants in California make up more than 1/3 of our workforce. They also contribute over 30% of our GDP. In addition to the large immigrant population, we have the largest population that will qualify for deferred action programs. So those are residents that can apply for protection from deportation, but also work authorization. You know, a robust economy really relies on a strong workforce, and we want to make sure that California is ready to facilitate the movement of these state residents into the labor force and not providing barriers or creating confusion through these types of notices for, you know, folks that are really trying to support themselves and their families. So for these reasons, the California Immigrant Policy Center stands in support of this legislation, and thanks Assemblymember Chu for authoring this bill. Thank you.
Thank you. Other witnesses in support?
Mr. Chair and Member Caitlin Vega for the California Labor Federation, also here in support.
Thank you. Any witnesses in opposition? Seeing none, any questions from our members? Seeing none, Assemblymember Lowe, would you like to close?
I respectfully ask for your support.
Thank you for bringing this bill forward. It's a great bill. Thank you for working on this important issue. And as soon as we have the right amount of members, we'll bring it up for a vote.
Thank you very much.
Assemblymember Holden?
Morning, Mr. Chair.
Morning, members.
It's a pleasure to be before you today. Thank you for the opportunity to present Assembly Bill 2068 relating to talent services. As you know, the evolution of the digital age created the convenience of having smartphones to function like a computer and expanded the possibilities of individuals to communicate with one another. With the unprecedented popularity of reality television and social media sites such as YouTube and Instagram, the quest for instant stardom has become prevalent between all ages, especially teens and young adults. AB 2068 updates the Talent Scam Prevention Act to accommodate newer forms of technology to include mobile applications, but more importantly, protect aspiring artists when communicating with talent agencies. I thank you, and I respectfully ask for your aye vote.
Thank you. Any witnesses in support? Any witnesses in opposition? Seeing none, any questions from members? Okay, seeing none. Oh, this one.
Thank you, Assemblyman Van Holden. Can you just go into a little bit more detail? You have talent agencies out there that get photographs of potential actors, actresses, musicians. They want their pictures, they want their videos in a library in the talent agency's archive so that they can show them to prospective film directors, music directors to market their skills. So what exactly does your bill do? That I just want to make sure I understand it correctly, that it's not going to impede the talent agency's ability to market their clients.
Right, no, it's not, but it does give the individual artists a little bit more control over the images, and sometimes and more times than not, you're looking at underage actors, and having their images out there sometimes without the proper controls can end up in a lot of different places, and so it's really giving them a little bit more control over the...
So would the talent agency have to get some kind of a disclosure from the client that allows them to market the child actor, if you will? The reason why my daughter is a talent agent in Hollywood, so I'm kind of curious how this is going to affect that industry.
Well, and it shouldn't, the industry, there are a lot of extremely reputable talent agency organizations that are out there, and so we're not really worried about those.
Okay.
But there are those that are not so reputable, and that's where this bill will allow, and it's actually building on existing law to kind of create, it's expanding, recognizing the new technologies to give a little bit more control to the artists so that they can get their material back and not be charged for it without, having a little bit more control over the product.
Okay, I just want to make sure it's not going to interfere with the traditional marketing of these actors and actresses that are looking for work, and these talent agents that are working hard to try to get them work.
Right.
So,
it really is sort of focusing on those that are less reputable.
okay, because they have to be bonded, and they go through a whole plethora of regulations just to be talent agents. So.
And it's all online, so you can submit your information, and you're really not sure exactly who you're dealing with, and then when you try to get the information back, that's when you have a little bit of problems. So this is just expanding.
If your legislation can kind of weed out these bad actors, that would be good.
Yeah.
Hollywood gets to know who those bad actors are pretty fast.
Yeah, no pun intended,
so,
right?
Anyway, I'm happy to support your bill. I'll move it.
Thank you.
Wonderful. All right, and at the appropriate time, that'll be your closing if you.
That would be my close.
Okay. At the appropriate time, when we have enough members, we'll bring up your item for a vote.
Thank you, Mr. Chair.
Thanks so much. Thank you for bringing it forward. Okay, let's go ahead and bring Lowe. As I remember, Lowe, please step forward. Right? Yeah. All right. Okay. Item number 4.
Thank you very much, Mr. Chair, for allowing me to spend AB 1050, which relates to variance proceedings, and which provides transparency to Cal OSHA standards boards and allows for operators to participate in the variance proceedings in which they get notified. Simply put, it allows for an opportunity to have the workers participate in variance hearings in which they're actually doing the work versus that of which a property owner might just have their employees participate in doing that work. And so respectfully ask for your aye vote.
Thank you. Citizen support.
Mr. Chair, members, Mike Monaghan on behalf of the sponsor, the International Union of Elevator Constructors. As noted in the analysis, we had heard this bill, you have heard this bill last year in a different form. It's been dramatically reduced in scope to apply only to variances from elevator safety orders. Notice will be given to those workers who will be actually doing the installation. This notice shouldn't be a burden. The International Union of Elevator Constructors has 2 locals in California, one in Pasadena, one in San Francisco. So if you're in Southern California, the chances are 95% if you contact the union in Pasadena or the board contacts the union in Pasadena, they're going to be right more often than not. The union, as I said, represents 5,000 men and women in California and does 95% of all these installations. So the notice requirement, in our view, is not a burden. Second of all, I think it's important to understand that this is not about the construction site. It's about a hearing. It's about a formal meeting with the standards board that includes the manufacturers, the Division of Occupational Safety and Health, and the workers. The goal being, of course, that we're going to try to provide a safe installation of the conveyance. as well as ensuring that this conveyance is safe for the public use when it's completed. Thirdly, with respect to party status, in 2014, the Department of Labor ruled that the Standards Board is within their authority to deny party status. So the part of the bill that gives party status upon request is necessary. We ask for your support.
Thank you. Witnesses in support.
Thank you, Mr. Chair, members of the committee. Jeremy Smith here on behalf of the State Building and Construction Trades Council. It's important to just reiterate we're talking about a variance from a safety order. I think if anybody should be notified about a variance from a safety order, it should be the workers who are actually doing the work. So we're here in support. Thanks.
Thank you.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also in support.
Thank you. Any other witnesses in support?
Also in support, the California State Association of Electrical Workers, the California State Pipe Trades Council, and the Western States Council of Sheet Metal Workers.
Thank you. Any witnesses in opposition? Please step forward. See you, Jeffrey.
Good morning. Marty Fisher with the California Chamber of Commerce, and we're here in opposition, unless amended. We have no problem, actually, we think it's a great idea to notify the unions about the variance application, and the Standards Board currently does that in its rules of procedure, although it's informal rules, but they automatically do that. They notify the unions. Since 95% of the workers that are doing the installation are members of the union, we believe that the union, as their authorized representative, that they're getting notified. The bill, the way it's written, also requires notification to employees that we don't know who else they're talking about, who they are. The variance, the terms of the variance and who has to implement a variety of provisions, a lot of them are administrative, management. We don't know what those provisions are when the variance is being applied for. So our amendments just ask for the union to be notified and not these other employees that we don't know who they are, because that creates a compliance and enforcement nightmare. And also, intervener status is available to anyone who believes they have an interest in the hearing. So we don't think that party status is appropriate.
Thank you very much.
Thank you.
Any other witnesses in opposition? Okay, any questions from, okay. The member, no, would you like to close?
Thank you very much for your opportunity and respectfully ask for a vote.
Thank you, and so we have the appropriate members here, we'll take it up for a vote.
Thank you very much.
It was okay. I had about 35%. I had a Cooper. So we just have this is the reason why. Oh, can I read it? This is why he said it applies to
Vice Chairman.